Well, thank you so much for hosting our webinar. This is part 2 of the webinar series. My name is Sonia Parras, and with me today are Cecilia Friedman and Maria Lazarino. Good afternoon, Cecilia and Maria.
Good afternoon.
And we have a full agenda today. As you remember, for those of you who joined us for the webinar series, the first part, we were covering a lot of issues of problematic um, topics with VAWA self-petitions, and we left some of them on hold because we wanted to cover them more in depth on our part 2. So today what we are going to do is to cover key points that you need to address when your VAWA gets a little bit complicated on the adjustment of a status. So we're going to discuss best strategies on preparing your case for adjustment of a status. We're going to discuss what questions to ask, where do you get resources to address the issues that you're encountering, where to go for information, and then we are going to be reviewing just selected inadmissibility issues and potential waivers that you may encounter again once your I-360 is approved or as you're filing the I-360 sub-petition along with your adjustment of status. And with that, I'm going to let Maria start talking to you about some of these problems at the self-petition stage. Maria?
Right, and I actually think that I am starting this conversation.
Oh,
Hello, everybody. No
Cecilia.
worries. No worries. This is Cecilia Friedman-Levin. Hello, everybody. I'm happy to be with you here today. And we wanted to begin kind of before adjustment, kind of with a little bit of a review of where we left off last time, because I want to talk about this is really the first place where we can see some complexities arising in a VAWA case. And if I can just get a show of hands from folks who are on the call, how many folks would say that they have a higher volume of other types of cases, like a U visa or T visa, than they do VAWA? Can you just raise your hand to kind of show me if you feel like you have a higher U visa caseload than VAWA? Okay, so I see a lot of hands as we go, and this is I think common, just because given the breadth of qualifying criminal activities that we see in the U visa context and kind of the very specific requirements of VAWA, that sometimes we might kind of not realize the assessment that needs to go into looking at good moral character, because I feel like many folks, and myself included in this, feel like you just need to jump into the admissibility land before really kind of checking in and understanding if there's going to be any good moral character issues. And it's not often, because honestly, just given the volume of the work that we do, that the good moral character bars at 101F really come into my radar screen. And so if you're looking at issues like smuggling, are you looking at that as a good moral character issue? And if not, then part of what we want to do today is kind of just check in, revisit 101F of the INA to make sure that you're screening for stuff at the outset. And so you're not just thinking about these issues at the time of adjustment and only in the context of inadmissibility, because there might be a step beforehand that you need to resolve. So again, some things that go into that is a criminal records check. And we need to kind of sometimes go under the surface and kind of go down the rabbit hole a little bit. Because, for example, if you're looking at the INA at 101F with the good moral character bars, and it says something like, okay, like aggravated felonies are an issue of good moral character. And you're going to be like, yeah, whatever, good moral aggravated felonies, that is super serious. It has nothing to do with my case. But then, for example, if you're looking at aggravated felony, that definition, which is at 101A43, then it says something about crimes of violence with a term of imprisonment for at least 1 year. And then you think to yourself, oh my goodness, there was a conviction for domestic violence in which the abuser might have called the police and that your client was arrested and convicted of a domestic violence, and maybe he or she had a suspended sentence. And so what does that look like? Could these types of issues also be crimes of moral turpitude, which kind of depends on the case law? But so you really need to kind of think about, if there are these issues, whether or not those types of things can be swept up in the land of good moral character, and if you're looking at them. And so there's some really great practice advisories on crimes of violence and assessing them that I'll definitely put into the web links once I'm stopped talking. But so just if you kind of do that cursory look through the good moral character bars, and if there's nothing that you really kind of are concerned about at the outset, you're like, oh, domestic violence, that's, deportability land, 237. What does this have to do with my case? You might have to go a little deeper and dig a little deeper into looking at the aggravated felony definition, looking at crimes involving moral turpitude, and see whether or not you have to kind of go down that rabbit hole in the context of good moral character and not necessarily just inadmissibility. I'm sorry if I'm speaking too fast. I get really excited about geeking out about this stuff. So please, if you need me to slow down or repeat anything, let me know. So again, even if these issues do come up, oh, could we go back, please? I'm sorry. So even if there are issues that come up, something that we had mentioned before in the previous webinar was that really wonderful USCIS memo from 2005 about good moral character determinations in the context of VAWA. And that if there is a waiver that might be available generally, and if so, whether or not you can make the argument that a problem involving good moral character has a nexus to the abuse that the person has suffered. And so it's important to kind of look at that memo, that even if there is a good moral character issue, even if there is a smuggling problem, or even if there's a CIMT issue, that you look for that nexus, if there is one, regarding the underlying problem, the bar under 101F, and the abuse that the person has suffered. And so that is a tremendous resource. It doesn't cure everything, like we're going to talk about in just a moment, but it is something to have in your back pocket and make sure that that you're looking at all those connections as you go. So we're going to go to a hypo now. And we're going to, this is a hypo, oh, I'm sorry, no, now I'm going to turn it over to Maria. I got excited. All right, Maria, so you can take it over and talk about some other issues that might come up. Oh, no, we are. Sorry, great. So we're going to go to a survey question now before we turn it over to Maria, who's going to talk about some other issues that might come up before adjustment. So what we have here is a hypothetical that we had discussed before in the first webinar, and that we are going to continue. So I'm going to fill in some facts before we read it. So what you need to know before we read this scenario is that Peter and Hilda recently married in Honduras, and she's 17 years old. She has a new baby, Griselda, who's 2 months, and she has another son, Manuel, who's 2 years old from a prior, but is not Peter's child. Peter is a United States citizen. And so Peter wants to bring Hilda back to the United States, but Hilda doesn't want to go and leave her mother, who is ill. And so with that, let's read. Maria, I'm going to turn it over to you to read this hypothetical.
Okay, thank you, Ceci. When Hilda refused to leave her mother, Peter took Griselda with him. Griselda was still nursing. Griselda was desperate, and when Peter sent for her, she agreed to come with her first child, Manuel, to join Peter and Griselda. They all drove through El Paso. When the car was stopped, the officer asked the coyote if they were all United States citizens. The coyote said yes, and they all entered the country. Is this a problem for eligibility of self-petition? Yes, no, not sure.
All right, so let's see what our
It's a
survey.
tricky one, no? But
Yeah, and people is changing.
Right, I love this typo so much. I can't even tell you. I mean, that it has a lot of different issues. There's a lots of different layers here. So I'm interested to see what folks think. And Alicia, I guess if more than half of the folks have submitted their answers, we can close it up. So if you want to give it just 10 more seconds. Okay.
Close.
Okay, so we have 70%, 73% say yes, 11.5% say no, and about 15.3% say I'm not sure. So there's a lot of different issues that come up. Actually, there's two that come up in the context of this hypo. It's slight hyperbole on my part. I'm sorry, but there's two issues. Can anyone put in the chat box what issues that you see? False claim, smuggling, good job, Jess. Yep, exactly.
smuggling, false claim, great, Jess.
Right. Oh my gosh, I'm so glad that
Shorter, willful misrepresentation.
you put an EWE entry. Yeah, it's complicated, right? It's complicated because, you know, right now, Hilda is 17. And in the statute, in 101F, it says the only exception specifically in the statute for children is if both parents are U.S. citizens who came into the United States before 16 and who reasonably believed at the time of such statement or claim that he or she was a citizen. And in other scenarios, it's complicated. It becomes really complicated. And there is a 8th Circuit case from 2011 called Sandoval versus Holder that talks about minors making false claims to U.S. citizenship. And what it basically says is that there's no blanket rules for minors about false claims, that you have to look to see someone kind of had the capacity to understand what they're saying. And in that case, what's really, really interesting, and forgive me just for geeking out for just a minute, it says that if the government conceded in that case is that you're an 8-year-old child, you know, whose parents makes this claim on your behalf, then that might be a different scenario for someone like Hilda, who is 17. So there's kind of factors that need to be weighed in this, and there are sections in the USCIS policy manual, and there's some really great advisories from the American Immigration Council as well. Also, what's interesting to me in this scenario, and I might kind of give away facts for a later scenario, so I apologize, Sonia, is this issue of being kind of waved through. And what does that mean in the context of having an admission to the United States? It actually counts as being inspected. And so we can talk about that. That foreshadows another hypothetical, but that's also an interesting part of it. And the other thing that people have identified is the smuggling issue. And so that is something that you would need to assess in the context of good moral character. And Jessica asks, wave through is equals to an admission, right? And I would say generally, but it kind of depends whether or not you were waved through with valid documentation. And if you were waved through without documentation, and if you're waved through without documentation, then that doesn't necessarily kind of give you any other specific benefit or entitlement because you were specifically waved through. And I'm going to put through an advisory by the American Immigration Council which talks about this in a little bit more detail and probably more eloquently and coherently than I just did. So these are some issues that you need to look at, not only in the context of inadmissibility, although you might certainly need to, but also kind of making sure you're doing the assessment and the analysis to look at these issues in the context of their moral character as well. Anything else on that, Sonia, you want to add?
Oh, well, what I wanted to add, and this is tricky, so you have to really state at the facts of your case. We conveniently made Hilda or Ilda be a minor, and I just wanted to point out that early last year, the Department of State announced that following consultations with the Department of Homeland Security, who is implementing the Foreign Affairs Manual, also known as FAM, was specifically being amended with regards to their position as to minors and false USC claims. So what they're saying now is that only no false claims to U.S. citizenship will be finding of inadmissibility. So again, this scenario is very convenient because perhaps, the practitioner.
Hi, I'm so sorry to interrupt. This is Alicia over at the National Council. Sonia, you are very quiet, and we're having a hard time hearing you.
Oh, really? Okay. Is this better? Is this
yes,
better?
Much better.
Okay, I'll yell.
Yes, thank you.
So I may be very annoying, but please let me know if I drop down my voice. So I was saying that you can, that I invite you to read the Foreign Affairs Manual because it's going to be, or it has been changed to implement the new position from the Department of State. And this was happening in the context of Mexico and Ciudad Juarez and kids being interviewed, but I think we could use it too. And they have changed the Foreign Affairs Manual to state that only knowingly false claims to U.S. citizenship with support of finding of inadmissibility and a separate affirmative defense was available to individuals who were under 18 at the time of the false USC claim, and as well that at the time lacked the capacity to understand and appreciate the nature of the consequences. So it has to be both component, and that's why again we made this scenario from ILDA so convenient, right? So I invite you to read the Foreign Affairs Manual on this point on knowingly false claims, etc. So.
Right, and the reason why the false claim issue is such a big deal, if we haven't said this specifically before, is that that is a bar to good moral character. That is going to be, very, very hard to deal with unless you can go through and make the arguments about why it shouldn't be. And so ordinarily, in most cases, if Hilda were over 18, then if she made a false claim of U.S. citizenship, this could be a deal breaker for her VAWA application. And you might want to look to see whether or not she qualifies for other forms of relief, like a U visa. So this is why we're kind of stressing this false claim as a major issue, because it is one that often comes up in the context of VAWA.
So Cecilia, what if Ilda, when she hears the coyote, well, first of all, I mean, Ilda herself didn't, well, when you talk about this, make the...
yeah, it was somebody else making the assertion on her behalf.
Very conveniently, right?
Yes,
anyway,
very convenient.
So what about if Ilda says to the officer, no, wait a second, I'm not a U.S. citizen, and she gets... I don't know, she gets fingerprinted, picture taken, and there is a negative entry that you find out in her Freedom of Information Act with CBP. Well, would you argue anything, anybody?
I think that you would argue that there is a timely retraction
there you go.
Of the claim, which is something that you certainly could raise. So that there were efforts at the very moment to retract and be like, no, like that's not the case. To try to kind of correct it, but I think that there is kind of and you can correct me, like a time issue there in terms of where it's timely.
Right, and you may see, I mean, we're going to see this a lot over and over, which is that a lot of times applicants, our survivors don't really know what happened, truly. Like they get all confused, they're nervous, they're stressed out, and they have gaps in memory, they can't recall, and that is why it's so important to get the records and to get the transcripts of the interviews that are available, which is hardly ever, from Customs and Border Patrol, or if they're accused of making a claim of citizenship, so you can see if there are any of these arguments that you can make. And of course, you have to know up front if this is an issue, so then you weigh the pros and the cons of presenting an adjustment of the status versus looking at other potential remedies, right?
Yes, absolutely.
All right. Excellent.
Okay. So Maria, what other things might be problems before we get to the adjustment phase?
Okay. Let's see these strategies and a review for all of you to have in mind in case that your client tells you that her husband or the abuser has filed some family petition in the past with the Immigration Service. So if you have a copy of the I-130, please try to locate the status of the application, and remember that regardless if the I-130 is pending or approved, you can preserve some timing. If the abuser was a United States citizen and filed an application, I-130 family petition, along with the adjustment of the status, you can preserve the adjustment application by sending a whole in abeyance letter and including the confidentiality provisions AUSC 1367. We have a sample of a whole in abeyance letter in our website.
Yes, and I just posted it in the web links.
Oh, thank you, Ceci. Remember also to send your G-28 along with a letter indicating that you are entering as the attorney or representative and you will be filing a VAWA case on behalf of your client. And please request that all documentation and correspondence in regards to your clients be sent to your office address. This is also a good moment to review all potential inadmissibility issues because there may be new facts or new situations and that may have changed since the previous adjustment application was filed by the abuser. If you realize that your client has some inadmissibility issues, this is the moment to prepare the waiver, and you can file the I-601 waiver along with the VAWA case at the Vermont Service Center. And remember always you can request fee waiver if you can prove that your client's income is below the poverty guidelines. Once your VAWA case is approved, which may take 8 months, you will receive a transfer letter indicating that your case was transferred to the National Benefits Center. This center will ensure that adjustment applications are complete before sending them to the individual district offices where they schedule the interview. So if everything is correct, you may receive the interview appointment notice in less than a year since you filed your VAWA case. If something is missing, you will receive a request for further evidence. And remember, we always say this over and over, to respond to the request of further evidence always and on time, even if you think that it is not correct or is wrong, but you need to respond. Otherwise, your case will be denied. In the case that your client was married to an abuser who is or was a legal permanent resident, you can use the priority date of the I-130 visa petition previously filed to file adjustment of a status application in the future once the priority date became current. One way or the other way, you will be saving some time for both you and your client. Let's keep going.
Can I make a quick note before we move on?
Yes.
So in addition to the abeyance request, I put in there, if you haven't seen it already, our latest notes regarding from the different events of USCIS. And what they have said, and this is something that is that people that, I'm sorry, I'm going to rephrase. District offices, when you're making this abeyance request, this is on page 25 of the link I just sent you. When you're making these abeyance requests, that they shouldn't necessarily be requesting any kind of specific documentation like a hospital record or a police report in order to do this. But you should be ready within about 30 days to file your I-360. And so then the other thing that we're seeing, though, and that we're concerned about is that kind of in that time period, in that 30 days, whether or not there's been any of these confidentiality violations. If, for example, they're sending notices to abusers and that you really wanted to make clear in the abeyance letter that the confidentiality provisions start, the safe address provisions should start, from the day that that letter is sent and people are put on notice. So if you're seeing any kind of issues regarding VAWA confidentiality being a problem in between that time period from the abeyance letter to the I-360 filing, please let us know and keep us posted, because it's not something that should be happening. And if we show that it is happening systemically, we need to raise it up.
Thank you, Ceci.
Hmm?
Now let's see what are the problems are working with issues at the adjustment of a status process. How adjustment works? As a general rule, we all know that an alien seeking adjustment of a status under the Section 245A of the Immigration and Nationality Act must have been inspected at a port of entry and neither admitted or paroled into the United States by an officer and be admissible as an immigrant. In October of 2000, the Section 245A of the Act was amended, and the inspection and admission or parole requirement does not apply to an alien who is seeking admission of a status as an approved VAWA self-petition. So we have other VAWA exceptions and waivers, and Cecilia and Sonia will talk about this more in detail, but we can mention the lawful presence, the permanent bar or reentry after removal, and we will go one by one in each slide. The public charge or the affidavit of support requirement for VAWA applicants, the visa fraud or misrepresentation waiver, public health, criminal grounds, and others. And one more review. What is one step versus two steps? If your VAWA applicant is or was married to a United States citizen, we know that she can file the I-360 application along with the I-485 application, and of course, what every client wants, the I-765, the application for employment authorization under 12C9, all together at the Vermont Service Center, one big package. Remember, you can always ask for a waiver at the Vermont Service Center. Also, the employment authorization document is processed by an outside agency. Therefore, prepare the I-765 application as a mini package with the form I-765, another copy of the G-28, an extra copy of the I-912, and a copy of the birth certificate, translation, and 2 pictures. The evidence on the employment authorization. Even if your client is married to a United States citizen, again, don't rush on filing the I-485 if there is any inadmissibility issue that cannot be waived. You can always file the VAWA case and request, as Sonia was saying in the beginning, a FOIA, FBI, final disposition. You can ask a FOIA to the court and obtain whatever document or whatever paper from immigration you need to determine that your client adjustment applications will be okay. If you are unsure about that, wait, and once everything looks good, proceed with the adjustment application. If it doesn't look good, you can just file the VAWA case and wait or explore other options. What happened with, let's go to the number 3. If the client is married to a legal permanent resident, then there is a 2-step process. Your client cannot file the I-485 with the VAWA case in this situation. She will have to wait the priority date that is shown in the I-360 approval notice, or in the I-130 there is the prior application that we talked in the prior slide. You will need to check the visa bulletin and the country of origin of your client, and when the date became current means that there is a visa available for your client. And this is important to explain to your clients because some countries have long wait lists and clients get desperate. And you may find yourself in the situation that clients go to your office and complain by saying that her friend who applied later has already the green card and why she does not. So explain the difference of marrying with a legal permanent resident and with a United States citizen. And the third option, which is in the screen, the one that is in the middle, when the legal permanent resident becomes a United States citizen. So your client was waiting for a certain period of time to the priority date to become current, and the user became a United States citizen. So in that situation, your client is ready to jump from one category to the immediate relative category. This is why it's super important to conserve the I-130 and to locate the case. Something else, Ceci or Sonia, that you want to add?
Yeah, there's some questions, and I'm happy to take them now.
Okay.
So Jessica asked, what is the best practice for the filing of the 765 under the one-step application? So if you are filing for work authorization under C9, which is the code that you would use to indicate that you want a work permit as having an adjustment application pending, then what I would do is on page 14 of the I-360 is a checkbox. I want employment authorization. And if you want C9, I would check that box, no, and then I would write C attached I-765 on the basis of C9 eligibility.
Mm-hmm.
Because if you check that box, yes, then what that means is that you're going to get a C31 work authorization upon approval of the I-360. Mm-hmm. So this is kind of super because you don't have to kind of wait that like 90 days, especially if you're filing on the basis of having an LPR abuser. Then you don't have to file a separate 765. You do have to file photographs with the I-360 and kind of the documentation that you would need to have a work permit, but you don't need a separate I-765 if you want C31 eligibility. But if you're seeking any other designation, if you're seeking C9 because you're doing a VAWA one-step, or if you're seeking one based on C14, deferred action, then you would have to check no on that box and then write in C attached 765 on the basis of either C14 or C9 eligibility.
And so, Ceci, what's the latest update? Because I know you were visiting with them at the stakeholder meeting in October or September. I don't remember anymore. But anyway, so they've been going back and forth, and, you know, they advise practitioners to file their I-360 along with the 765s, and they were holding the 765s until the I-360s were approved to then grant the EAD immediately upon approval. And
yep.
Then they started saying that this was a practice that was not going to continue because of the regulation that unemployment authorization must be granted within 120 days. And then, so they're driving us a little bit crazy going back and forth. So tell us, Cecilia, what is the very latest on the whether we file 765s with I-360 or not?
Well, a few things. That the advisory that notes and practice pointers that we just sent out, I just want to, for full disclosure, is that was something that was prepared with assisted own private funding so that the field in general can kind of get that information. So that disclosure aside, that what we've heard is this is a real complex situation because what I just mentioned now in terms of filing the 765 concurrently with the I-360, I don't think it matters so much in the C9 context because that's something that is kind of a typical turnaround anyway, and that's done because of the application is pending. So that is something that has a quick turnaround. The issue that we're seeing, and this kind of is going slightly off topic because I think this is probably more germane in the U context than in the VAWA context if you're applying for deferred action, is that right now this is the process that you are able to have these concurrent filings under C14 for VAWA, for example. Whether that will be the case in the long run, I believe that's an open question. So I'd say for now, continue filing as we have been. But in general, I think that this is something we're going to have to kind of keep our ears and eyes open and see how they eventually do this down the road.
And so I'm sure those of you who are listening today have had mixed rejections on filings because that's what we're seeing in the practice. In the practice, we're seeing even on new visas and on VAWAs how some of the EADs stay with the filing, yay, right? And then we get the notice of receipt, fine. But then we're seeing also some rejections of 765. So what that tells me is let's just file it, right? Because I would rather have a rejection and then correct it than miss the opportunity. So let's continue to file those 765s, and then please tell us what is happening because this is something that Assista can also bring to the attention of Vermont Service Center. Just for example, just leaving this topic for a split of a second, we've been getting rejections on C14, Cecilia, and what we have done is refile and do a very bright cover separation divider that says do not return, keep on file, because I know that some of the people that work in the mailing room may be separating cases.
Exactly. I think it'd be a process issue rather than a policy one.
So we're just telling them in bright yellow paper, do not separate, keep on file, and flagging it for the mailing room, for the adjudicators, so we stop seeing these rejections. Totally off topic. Let's go back on.
Well, it's related. It is adjacent.
All right.
Okay. Let's keep moving. When we are at the interview, so we are now at the interview step. And remember again what Cecilia was telling about the AUSC 1367, the VAWA confidentiality provision. Please, your client's I-360K has already been adjudicated, and the immigration officer cannot and should not ask questions in regards to the abuse, in regards to the I-360K. Cecilia was telling also about the VAWA confidentiality provision. Remember that they prohibit disclosure to a third party of any information relating to a person who is an applicant for relief under VAWA with some limited exceptions. And remember that there is a process if the provisions are violated. If we go to the identifications, all adjustment of status applicants must be present on the interview. This is super important. Make sure you go with all the kits that are included in the I-360 application and the I-485. Ask your clients, please, to take the employment authorization card, IDs, the social security number, original birth certificate, and any other related immigration notices. Also, if your client has a passport, she can take it with at the interview, because if the green card is approved, she can get a stamp on the passport. And attorneys, please take the file with you at the interview and become familiar with it. Also, a few suggestions or best practices. Review the I-485 questions with your client, always, at least 2 weeks in advance, to avoid surprises at the interview. And if it happens that your client disclosed something that you think it may be a problem during the interview, you can always reschedule the interview and prepare a waiver if needed. Do not go to the interview if you know that your client has some inadmissibility issue that was not taken care of. You can also stop the interview if something happens during the interview. If your client is lying and you notice that he's getting into trouble, you can request the interview as well. And the same if the officer is violating the VAWA confidentiality provision, request to stop the interview and follow the instructions for reporting of the violation. And a few notes about interpreters. Make sure you have one when you go to the interview. Even if your client say, I understand English, it may be way different to understand to the kids than to understand to an immigration officer. So go with a client, go with an interpreter, make sure that your client is not planning on using the kids as interpreter. And if it is a new interpreter, make sure that you test it before going to the interview, again, to avoid surprises. Be as prepared as you can to the interview. Let's see if we have any questions, Cecilia.
And no, I was just going to say, don't hesitate to request an extension of the interview if you have issues with finding an interpreter. In general, in some local districts in Iowa and Nebraska and other places, they will call the AT&T language and have the interview if you let them know in advance that you have issues with the interpreter instead of continuing it. But you can also take a letter with you to the interview and that same day request continuance. It'll be nicer if you do it way in advance so they can reschedule and they don't leave that gap in their scheduling as well. So just some practical considerations.
Okay, let's keep moving. What do we do about the kids? What do we do about derivative kids here and abroad? So, number one rule, make sure all kids are included from the very beginning. All kids residing in the United States and abroad should be included in the I-360 VAWA application. And ask your client many times for all the kids, especially for the ones that are living abroad. You may find that some clients are ashamed for leaving the kids with some relatives in their country of origin, and they will not tell you the truth, or they will try to hide that they have kids in another country. So please, ask more than once and explain why it is important to tell if there are any kids abroad. Once the kids are all included, make sure that when you get the approval notice for dependents, that all the kids that were originally in the I-130 and mentioning in the approval notice for dependent with correct name and date of birth. If there is some mistake on a spelling or on the date of birth, make a request, make a correction. If not, you will have problems later on at the National Benefits Center. And super important, one more tip, make sure to explain your kids to your client that the kids included are unmarried another 21 years. So kids must remain unmarried until the adjustment of a status is approved. This is in general for kids. Now let's see what we do with the kids here. The kids here can file concurrently or after, but not before the principal. The principal must adjust first. You can always do one big package with all adjustment of a status application and send to the Vermont Service Center and request fee waiver for all. If the kids age out, they will be able to continue with self-petition, but will change categories from F2A to F2B. If it still get aged out, explore on self-petition and do not marry. And the self-petition are for kids until 21 years old. The kids, again, will need to go to the interview and bring IDs for the kids as well. What we do with the kids that are abroad. In the past, we have to wait until the VAWA applicant becomes a legal permanent resident to file the I-824 follow to join application. This has changed recently, and now we can file the green card for the principal along with the I-824, all together at the Vermont Service Center. Again, you can always request a fee waiver also for the I-824 application. Even if the immigration officer will not review the I-824 until the adjustment is approved, this helps and saves time for both you and your client. When the I-824 is approved, the Vermont Service Center will forward the adjustment application to the National Benefits Center, and you will continue with the consular process. Please be prepared to educate the consular officer. All consulates have emails in case you need to communicate with them. Google the consulate where your country, where your client is living, and find the email in there. You may experience some delays to the field officer not contacting the applicant for an interview, although the visa was already forwarded to the district by the National Benefits Center. And super important, be aware of passport issues, custody issues before you start the process. So you do not delay the process for lacking some notarized permit for kids traveling abroad without parents, or with only one. And remind your clients that she will have extra expenses for medical exams, for transportation, etc. I don't know if you need to add something else, Sonia Cecilia. If not, we keep moving.
Alrighty, so I'm just pasting the website to the Department of State. As you can see in there, state.gov, where you can find all the specifics on whatever country of origin your client is from, so you can look at the different rules on appointments and interviews, etc. Once you have that 824 approved and you're moving with the National Visa Center. All right,
And
so, yes.
Give me a second. And the IA-24 are still application kind of new for all the consulates. So you may need to start the process of educating your consulate if you are going to be dealing with VAWA, this kind of consular process. I will say one thing about the flagging inadmissibility. Immigration language is complex, and client may not be familiar with the terminology or the immigration concept. So what do we do? How do we ask to ferret out problems? How we can frame the question so your clients try to answer the best way they can. Please be respectful with your client when asking the question, and explain about the confidentiality, that you will not be discussing anything she's telling to you with anyone outside your office, just with the staff, because it is your team. You work with a team. Close the door of your office and be in a private space when asking questions, and explain questions if your client don't understand them. Also, explain very polite why are you asking those questions, by saying, for example, that it's not because you want just to know and are curious about how she get in or out this country, but because you need to know if there is any inadmissibility or any problem with it. And there are some, I will mention a few examples if we want to for example, know how she entered the country, how your client entered this country. You can say, when did you enter for the first time, or how old were you when you first entered into this country? Was your last entry the same date as your last entry, or have you ever been back home since your first entry? You can make slightly different, try to obtain the same answer. If you want to know some encounters at the border, you can ask some question about if have your client been in front of someone using a black robe, or if he have ever been detained, or if he has fingerprinted at the border, or was trying to get into the country, and what happened then. And remember, always super important to ask questions about false papers, use of documents, or social security number to work, to enter into this country, and at the Department of Transportation to try to obtain an ID or a driver license.
And why is that, Maria? Why do we need to know now more than ever those kind of things?
Because the Department of Transportation will refer your case to the ICE or will investigate your ICE. And sometimes clients use made-up social security numbers, or the other time they use social security number that belongs to a United States citizen. So you need to know what kind of number was she using. And as we were seeing in the example with Hilda, let's ask question about the kids. How the kids enter into this country? Did you pay the coyote to bring them in? Or did you give the coyote the birth certificate of your oldest kid to bring the kids that were abroad? So ask the question in different ways to try to obtain the more answer, and explain the question. The immigration terminology is very confused for our clients. So Sonia, what are the most common problems? Can you explain that to us?
Yeah, so just moving on. So let's talk about, how to not only ferret the issues, what kind of questions do we need to ask, and why are they important? So basically what I would advise you all to do, and I know that you have done this a million times, right, as practitioners and working on VAWA, self-petition cases, and going to adjustment of status, you need to open your INA and look at INA Section 212 and go through all the grounds of inadmissibility and start thinking proactively, what kind of questions do I want to ask my clients that will jiggle their memory and that, will make them feel comfortable enough so I know that I have an issue. This is very important because there is nothing worse than sitting in front of an officer the day of the adjustment of his status, have your client, throwing up a bunch of inadmissibility issues that perhaps you had a waiver for that you could have prepared. So let's go just through some of the ways of jiggling her memory and asking these questions on entries and exits. This is a very simple one. They may not know very well, what month of the year we can ask about entries and exits, whether it was summer, whether it was hot, whether it was cold, what kind of clothes were they wearing, to give us kind of like an idea of the time of the year that they enter. More than anything is also to be aware of any unlawful presence that may have been triggered by overstaying 180 days or 365 days, etc. So I would advise you to sit down and do a line, just a straight line, and start talking about ins and outs, and have that in every single meeting that you have, just to refresh her memory, because at the beginning she may not feel comfortable enough to tell you about it, or she may think that she's in trouble, or she may think that because no one saw her, right, then she doesn't have to tell you. But then she goes in front of the adjudicator, and here she is telling the adjudicator all the entries and exits. So draw the line and start talking about ins and outs, jumps, and trying to figure out times. Sometimes they remember because of the birth of the kids, or because someone's birthday, or because it was the Virgin Mary holiday in her hometown. So those are things that may help her remember. Of course, you absolutely want to know whether those entries and exits happen before or after IRA. If you are as old as I am and you have worked for as long as I have, you're going to see those clients who really didn't quite matter because maybe they came in and out in 1990 and 1991, and then they made their entry in 1995 and never ever left without any encounters at the border, without any removals, without any issues. So again, when and how many, right? And most importantly, did she know back then, as she's jumping in and out, her abuser? This is so important because to me this is what is going to determine whether I look for an additional remedy or whether I move forward and I really work on my personal affidavit and try to get as many evidence as possible to make her as strong, credibly wise as possible to prove that reentry connected to the abuse. Manner of entry, and I can tell you that at the beginning, I thought that by speaking in Spanish, my client was understanding what I was saying, only to learn that that's not the case. We're speaking sometimes, even though we're communicating in her language, her native language, we're throwing legal terms, we're throwing concepts that don't register with her. So let me tell you one, for example, in talking to my clients about the manner of entry, whether they came in with inspection or whether they were admitted. So this is what I learned and what I tell them. Did you run through the desert? Did you swim through the river? Did you walk through a bridge? Did you jump in a plane and took a plane that landed? Because that's going to tell me whether she entered without inspection and was not seen or detected, or maybe she was encountered and she got a voluntary return, whether she perhaps committed some sort of visa fraud by going through the breach, or some sort of misrepresentation, A212, 212A6C, any sort of claim to citizenship because she walked through the breach, So those are very important questions, again, to determine in the manner of entry, whether there was a visa fraud, and whether we're going to need a waiver. Because the first thing that happens when you hear your client saying, I crossed through the breach and show some papers, you can't help it by thinking, okay, that's it, we're done. There's nothing we can do from here. While that's not the case. We need to explore whether, she was using perhaps a mica chueca, like the false green card, or she was using, like I had a case where there was someone working inside of the government, obviously, that got her B1, B2. She took her passport, paid $500, and she got the stamp. So obviously that wasn't valid. She didn't have an interview. She didn't go to the consulate. It was just like through the back door. So anyway, so those are the kind of things that you want to know before filing the 485, the adjustment of status. Smuggling. I don't know how many clients forget that they brought their kids. And then at the time of the interview, the officer says, do you have any children? She tells all the USC children, do you have any kids that were born abroad that you left in your hometown or, that you had abroad? Yes. Okay. Who brought that child here? Oh, me. Oh, wait. We have a problem, right? So talking to them again about how they made the trip, and how they get into the States, and how many times, and if they left, and if it was connected to the abuse, and if they brought their children themselves or had anything to do. I had a client that said to me, well, I didn't bring him physically. I just paid for the coyote. Okay, well then, that's also smuggling, right? Okay, so um, were the children undocumented? Sometimes we kind of assume that they're all undocumented. Well, perhaps the children were born in here, and then she had to leave, and she brought her USC children with her, right? So more things, encounters with the Department of Homeland Security, encounters with immigration, CBP at the border. Very important. In case of doubt, stop, think, fingerprint your client, file a Freedom of Information Act with the Customs and Border Patrol, and also get the fingerprints to the FBI, because not always 100%, but it should. If she was expeditedly removed, you're going to figure that out. You're going to find out through the FBI faster than perhaps through CBP. Also, you need to learn how to read the records from the FOIA. There are some key, and perhaps we can do a webinar only on FOIAs, but there is some key language that suggests that your client has re-entered. So you want to explore all those things. If your client is not from Mexico and she was pushed back at the border, what happened in there? Was she pushed back, or was she let in and provided with a notice to appear? Did she follow up with that notice to appear? Does she have now an in absentia order of removal? Was she caught at the border? A lot of the clients tell me that the coyotes prepare them to say that they're from Mexico, so they're pushed back and they can re-enter quickly. And it happened at the border. But if it happens more than 100 miles away and they're placed on a plane, chances are they were indeed deported. So anyway, so all those questions are important, and all those things are key to your client's case. On unlawful presence, so as we know, on the cases of VAWA, we are adjusting under 245A, so we don't have to worry so much as with any other general cases about whether she worked with authorization or without authorization, unless she made, please check this out, unless she made a false claim of citizenship when she filled out a Form I-9. Yes? Oh, I thought I heard something. So the Form I-9. So what? Okay, so what I do is when I meet with my client, I put in my computer the Form I-9, or I print it, and I ask her if she remembers filling out or checking out any of those forms and whether she has made a claim of citizenship that way. On unlawful presence, so VAWA self-petitioners So three situations, right? She's living in the U.S. or she's outside of the U.S. or she was in the U.S. and then left and came back. So for VAWA self-petitioners living in the U.S., we don't need to worry about these grounds of inadmissibility of unlawful presence because they can adjust their status here, right, in the U.S. without departing the U.S. for a consular interview. So that's pretty convenient, right?
Right. As long as we have the one with the Refil, that's the servable one, that's all we really
I'm sorry, Cecilia, I'm hearing some background, but I don't know if
need. No,
you're...
I think, yeah, I don't know if, Alicia Maria, your lines are open. We're hearing some background noise.
Okay, so because I keep stopping thinking that someone wants to jump in. So,
I know.
anyways, so that's your INA 212B9 little III Roman numeral 4 ground, right? Now, if she has re-entered, and we said this at the very beginning, but if she has re-entered the U.S. unlawfully after she has been ordered removed or she has spent more than a year in the U.S. unlawfully, then in general, a person will be inadmissible permanently. However, as a VAWA self-petitioner, you can apply for a waiver of this ground of inadmissibility if you can demonstrate that connection between the abuse that you have suffered and your removal or your departure or your need to re-enter into the U.S. or whatever was the activity that triggered that bar, right? So that's INA 212A9C.
Skeleton crew going today.
Alicia, I think your mic is open and we can hear the background conversation. So, alrighty.
We'll let you know.
Sonia, we have a question. Can I read the question, please?
Yes, absolutely.
So it's Jessica. She's almost certain the answer is yes, but she wants to confirm. If an individual states she has used a USC Social Security number to work, knowing it belongs to a U.S. citizen, does that sink the VAWA, even if she did so to work because of financial abuse?
Absolutely. That is already, farm case law. And some adjudicators, unfortunately, go after that specific question and may request or subpoena the employment records to find out whether the I-9 was signed making a claim of U.S. citizenship. So before 2009, again, those of you who are older, you may remember that the I-9 had some very blurry language that would say, have you ever, or are you a U.S. citizen or a national? Are you a lawful permanent resident, et cetera, down the line, right? So because of that dual potential interpretation, practitioners often argue that because it could have been a U.S. citizen or a national, there was no claim of citizenship. So in 2009, the I-9 is changed, and actually I need to let you know also that the I-9 has been modified as to last week again, so you need to look at the latest I-9 employment verification form that the women the survivors are filling out now. Very important. Some of them are going to say, I don't know what I did or what I filled out. I didn't do it. I didn't fill it out. So we're like happy thinking, oh, we're going to be able to make a claim that there was no intent because she didn't fill it out. All the I-9s are signed. And if they're signed and they're signed under perjury, then immigration interprets that as if that is your signature, that is your claim, that is your form. So be very aware of this situation. We also know in general that, the I-9s are kept for a number of years, but you need to look at, again, whether the person is working under the table, whether the person is using if it's being paid cash, or whether it's working for a corporation or an agency that is more likely than not require that I-9. So be very cautious with that because Vermont's representative is going to approve that case, even though you said that you were working and that you were working for Walmart, et cetera, et cetera. But when you get to the adjustment of status and you are in front of your district office and in front of your adjudicator, they're going to dig for that, and they're going to ask that precise question. And it's very likely that they're going to subpoena those I-9 forms to see what you checked. So long answer. but I think it's very, very important because I know that we have some VAWA cases that are shut down, and we look at other avenues, U visas or any other potential remedies because we know that they're going to make a finding of claim to citizenship. Ceci, do you have any other more hopeful comments than mine?
Move on.
Yeah. No, I think that you covered it. Great.
All right. So something not to look forward to. So visa fraud or misrepresentation, again, remember that if the person got a B1, B2 with the intention to immigrate into the U.S., that's, fraud, and that there are waivers for that. In the cases of the um, VAWA applicants, fortunately, you can apply for the waiver, and in order to qualify, you have to show that either you yourself or your qualifying parent or child will suffer extreme hardship if the waiver is not granted. If you guys do like general practice, this is like a 601 or a 601A, I think even to a lesser standard, although I would always advise you to do the best case and present the best case and the strongest case that you can. So you can look at the 601's waivers, and we're going to talk about that later to see how they're put together, but the instructions are very, very clear and include some tips and instructions for VAWA self-petitioners. The health-related grounds in general.
Right. Yeah, so we're going to talk about this a little bit further,
Yep.
Sonia, if you want to
Okay, so I'll just move on. So criminal grounds, waivers, 212H, etc. Alrighty. So in general, this is what you do. You argue that the ground doesn't apply at all. Okay, so if it is on criminal grounds, if it is a fraud issue, you break down the elements that trigger the ground and show how they're lacking. You may need to get the statute to break it down and make sure that your argument is solid. What I normally would advise you to do is that if you have doubts about your arguments, then look at any potential exceptions. Either the ground doesn't apply or there is an exception, like in the crimes of moral turpitude and the connection to domestic abuse. And then when you say no to, I cannot make an argument, and no to, I don't find an exception, there is hope, because even if this is true, you may still be eligible for a waiver. One thing that I wanted to point out in terms of the good moral character bars, we don't have enough time to go in detail over this. We introduced it during the first webinar. Super important that you read the Paul Novak memorandum dated January 19, 2005, and I'll put it in a little bit for you guys, the link so you can go in there, that talks about the determination of good moral character in VAWA-based self-petitions. And this is, again, very important, and I want to point at the very last pages. It basically breaks down what I just mentioned, how the officer is going to make that kind of determination as to whether there is an issue and whether there is a waiver or an exception. But in the attachment 1, you have a beautiful 4-pages table that breaks all INA Section 101F and tells you whether the conduct is waivable, the waiver provision, and the criteria for waivers. Good faith marriage concerns. This is something that we're seeing, and I put it in there because in the technical assistance that we provide to practitioners like you, we're seeing this issue more and more. So the most important thing in there is to find out whether there is any detrimental information against your client in any other relations. I mean, it's kind of late in the game when you're going 100 miles per hour with your I-360 and your adjustment of the status, only to find out that you get to the adjustment of the status and, oh yeah, I was married before for just 3 months, and my marriage was determined by the adjudicator to be a sham marriage or a fraudulent marriage. So those are the things that, again, you have to get to know at the very beginning and get the exact information on whether the actual marriage ended up in a petition and ended up in an adjustment of status or an interview and an I-130, so you are prepared. Address all these things in your self-petition at the very beginning, the good and the bad stuff, because that's going to set the stage for later continuing with your arguments on adjustment of status. And I know we're kind of running out of time, so we're going to escape this adjustment of status survey, which was very similar to the things that you already saw. And I think Cecilia is going to take it from here. Cecilia?
I am. Okay, so we are going to really dig down deep, and I'm excited about this webinar today because I think that we get to drill down on these details and these specifics and remind ourselves about all the different ways that VAWA self-petitioners have access to specific waivers for them, and how we might not think of these issues that come up for our clients, that we're able to kind of look at them and see how they might be able to qualify beyond what someone else who is not applying for VAWA has in terms of their adjustment application. And there are really, we talked about the issues in terms of the moral character. We talked about how you would frame the issues in terms of whether or not it applies. Are there exceptions? And if there is not an exception, is there a waiver? And there are several ways that this can come up in terms of inadmissibility. And there are certain grounds that there are VAWA-specific waivers. There is a waiver in 212G for communicable diseases. We'll talk about that in a bit. 212H waivers for criminal conduct. We'll talk about that a little later. And then also 212I for fraud, as Sonia mentioned. And then the 212A9B waivers, which is the waiver for unlawful presence. And then we have the 9C3 waivers, which is for unlawful entry after having unlawful presence for a year or after an order of removal. And so we're going to talk a little bit more about those in detail for the next slide. But even before that, even before we get to kind of the inadmissibility issues that kind of come in the waivers that are specific to VAWA applicants, there are certain kind of gateway issues that we can kind of breathe a sigh of relief. It's not that often we can breathe sighs of relief in immigration cases, but it is nice when you find those moments where you're like, okay, this is one thing that we really don't have to worry about. That is a rare thing. And so I want to be able to highlight kind of those three moments as it relates to VAWA applicants. For we have, I just put in the web links folder, there's a USCIS memo which talks about VAWA and e-reentrance. And so there, if you kind of take a look at that link, and if it's easier for me to put it in the chat box, I can do it there. And this is a memo which is from 2008, which talks about how an e-reentry is not going to be problematic in terms of filing for adjustment. And so that is kind of the first sigh that we can breathe when we're talking about an e-reentry. Again, if we're looking, if I want to complicate it, if we have an e-reentry after removal, if we have an e-reentry after voluntary departure, if we have an e-reentry after a year of unlawful presence, then that kind of complicates the matter. But if someone has simply entered without inspection, that is not going to be problematic in terms of adjustment under VAWA. The same holds true when we're talking about unauthorized employment. And the USCIS policy manual specifically states that the bars, which is an INA 245C, don't apply when you're talking about VAWA applicants. And so that unauthorized employment is not necessarily going to be problematic for a VAWA adjustment. And the same thing that we're looking at is when we go to someone who might have had a valid illegal entry but has since fallen out of status. And so those are three things that, again, absent kind of talking about specific waivers, is not going to be, in and of themselves, any kind of barrier to applying for adjustment under VAWA. And thankfully, in the VAWA applicants, and as of VAWA 2013, UNT applicants are exempt from public charge grounds of inadmissibility. And so normally that means that you have to file an 864W, which is the waiver for having the affidavit of support. And then we had talked about here about whether or not there's any kind of issue if, for example, I know that many of us had VAWA applicants who are still living with their abuser and filing for self-petition. Sonia, has this come up for you at all?
I'm sorry, the affidavit of support?
Yeah, with regard to if an applicant is living with their abuser?
No, not at all. And this is one of the things that is very concerning to clients. They may want to lie about living with the abuser, and of course we need to advise them to be upfront. And I know, Ceci, that this is an additional issue in here, but if you lie then and they find out credibility is an issue, obviously, and if the adjudicator has an issue with the approval of the I-360 because the client continues to live with the abuser, there is a special procedure and protocol for that. So be always upfront. But no, we have this claim, the continuous residency with the abuser, and this has not been an issue. So.
Okay. Okay, when we're talking about the public health grounds of inadmissibility, there is a waiver that is specific to VAWA self-petitioners, and as I understand it, that relates kind of specifically to the communicable disease element of it. But that if we're talking about the other parts of the public health grounds of inadmissibility, specifically kind of a waiver for a physical or mental disorder, which is kind of a harm to oneself or other people, or the vaccination requirement. My understanding is that those specific waivers they would need a general waiver, but that there is a VAWA-specific waiver when we're talking about a waiver for communicable diseases. And so there's no need to kind of show any kind of relationship if you're seeking a waiver of that communicable diseases, that it just by virtue of one being a VAWA self-petitioner, that you're able to apply for that.
I was just going to remind everyone that HIV is no longer an issue.
Right.
So, and this is important because, it seems it is a big deal. It is a horrible disease, but you do not need to seek a waiver for HIV.
Right. And so now we get a lot of technical assistance around permanent bar issues. And when you are looking to file a waiver under 212A9C. And so when we are looking at these, so this is, for example, if you enter EWI after having a year of unlawful presence or after having a previous removal. And to be eligible for this waiver, you have to show that there is a connection, a nexus, between the abuse and the removal or the departure or the reentry or the attempted reentry into the United States. And there's been a lot of case law around this issue. There's been a lot of case law if, for example, that there was abuse that one was escaping in their home country that's not related to the abuse that is the basis of the VAWA self-petition. Those cases have not been looked at well in terms of the appellate level and distinguishing those from when the abuse that one suffers is related to, for the waiver, has to be related to the abuser under which is the basis of the application. And so it can be really, really complex. There's not a ton on this. And so we, in terms of established case law, in terms of does it have to connected to all of these things? Does it have to be connected just to one of those things? And so, in which one of those do you need to have that? And so what we say, be careful, call for help, we mean it. If you're coming across this permanent bar issue, the process is a little bit distinct, and we want to make sure that we're here to help you walk through it and kind of walk through the process, the forms you have to fill out, and making sure that you're approaching these cases in a way that is going to be favorable for your client.
So let's dig a bit more into this issue of permanent bar and reentry, specifically after removal. So there's a diagram in there that I'm going to walk you through, but very important to me. It was so easy to understand the complexity of the issue by reading that advisory that Trina Realmuto from the National Immigration Project put out in 2013. So that's why I have that linked in there for you all. Night reading, bedtime reading is actually very helpful to follow and understand what the issue is and what the old law and the current statute states. So basically, your Section 212A9A makes individuals who are removed or deported inadmissible for many years after that removal, right? So this inadmissibility period may be waived if VHS grants consent or permission to the admission. And this request for permission is filed on Form I-212 and is commonly referred as to I-212 consent to reapply for admission. And if you see in the slide before, we put in there the regs that are pertinent, which are 8 CFR 212.2, and this implements the consent to reapply for admission provisions. You should also read, and I'll put it up in a second, the memorandum from Paul Virchuk on what is dated, is an old one, it's 1997, but it's also very important to read in conjunction with this advisory because it basically gives additional guidance on the implementation of A212A6 and 212A9, which is relevant in here. It's just, to make the long story short, there was a case matter of Torres. It's a BIA holding, the inadmissibility of VAWA to reapply for admission. But then, like a few days after that, we have VAWA reauthorization 2005 and some provisions that explicitly confirms that 8 CFR Section 212.2 continues to be good law. So what the bottom line is that the Secretary of Homeland Security and the state have authority to grant I-212 waiver applications, and also the Attorney General has authority to grant this I-212 waivers. So if you have a case of a client that was removed in the past and that the reentry was connected to the abuse, then you could explore the possibility of a 212, which otherwise, would have your client at a higher risk of being reinstated that prior removal order, right? So if you have a case like this, you can send us an email or a technical assistance, and Gail or Cecilia or myself will help you analyze the specific facts, make sure that you have a strong case, and try to do this combination of the I-212. What happens is that if you have a woman that is married to a U.S. citizen or married in the past 2 years that can have one of these applications to or consent to reapply for admission cases, you will present everything up front. So you will file your I-360, your 485, your 601 waiver as needed, and your 212 application to reapply for admission. If your local people are educated and have done more cases like this, then it's perfect because you're not going to need any guidance or assistance. They already know what to do and how to do it. If you check with your director and they have never heard of this, then you may need a little bit of help from a CISTA on this. Once the cases are with the Vermont Service Center, if the I-360 is approved, then the case is going to be forwarded to your locals, and that is why it's so important that before you make these moves, you make sure that your district director gets that specific basis for the I-212, that you have a strong case, and that your 601 is likely to be adjudicated at the same time. Alrighty. So when your client surprise, and again, this is a complex thing, so I advise you to go and read that advisory and ask follow-up questions if you have any additional questions or cases that you want to consult with us. So again, the key is always right before the interview, one more time to meet with your client. And even though you met with her, you followed all these tips, you have reviewed the I-212 with her 1,000 times, that you do it one more time just because for some reason when they're closing into the interview, there are things that they remember. So you want to know all those things before the actual interview.
Sonia, as we only have a few minutes left, so I don't know if
I'm
you
sorry.
we only have about 3 minutes left if you want to see
Okay, so
any
just
questions.
really quickly, make sure that there is no criminal activity from the time that you presented the 485, which may be 6 or 8 months to the time of the interview. Look at any credibility or contradictions between the I-360, any prior marriages, any prior filings with USCIS that you need to clarify. And always, 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 it's safe to request a continuance as needed, so you are better prepared. You can explain those contradictions or those issues that that came up as a surprise when you're close to that interview. And I think we have one more slide for you guys to do resources.
No, I think that we had discussed the additional waivers about for fraud and extreme hardship and about for CIMTs. And I think that those important to kind of go back and look at them and kind of make sure that we understand the definitions of extreme hardship and what are our resources for extreme hardship. There's this really great 1998 Paul Virtue memo Sonia mentioned that kind of talk about it when hardship was an issue for VAWA, which has since changed. But it's really helpful guidance. We can look at it in the T visa context and kind of make sure that we understand extreme hardship, make sure that we're making arguments of discretion, which we are all used to doing in the U visa context. And when you were kind of framing these waivers and working with these waivers, because those are kind of the same types of formatting and the same types of template is going to be helpful when we're talking about the exercise of discretion in these types of waivers. So we only have literally a minute left, so I apologize for running over on our content. And if you have any additional questions, then please feel free to reach out to us directly. You can reach us through the questions at assisttohelp.org, or that Sonia and I can also talk to you directly. So just want to thank you for your time today. Any last thoughts, Maria or Sonia?
Well, just briefly remember that as of December 23rd, any cases that have not been actually received by the service are at risk of having the new fees applied. Look at USCIS, see the new fees schedule, and there are several forms, including the 601, including the I-212, the 765, that you may get a waiver for, as well as the other forms that I just mentioned on VAWA cases, but all of these are going to be raised. So just file your cases quickly. Maria, anything else from you?
No, that's it. Thank you. You have the resources slides with our website and our email for questions if you have some follow-up questions, please.
Thank you so much.
Yeah, thank you, Alicia, for helping.